thank you all very much for coming. Again, I am Benjamin Premack. I'm a partner at Premack & Rogers. You'll see on my business card it still says the Premack Law Office, but I am forming a new partnership with another attorney named Dan Rogers. We're going to be getting it all together in the next couple of weeks, so we're starting to use the same name. My email address on the card will be just fine. So a little bit about me. Again, I'm a partner at Premack & Rogers. My practice is almost exclusively representing video game developers and publishers, mostly in the Bellevue area and the Seattle area, but also throughout the United States and internationally. My primary practice areas are intellectual property, which is mostly what we'll be focusing on tonight, contract law, business and corporate law. So another thing we'll be touching on tonight is when and if you should form an entity, and the purpose for that. And then also helping my clients deal with publishing and developing agreements. So from the publisher side, negotiating with the developer, and vice versa. So a couple of obligatory disclaimers. I'm not your lawyer unless I am. And this presentation is for informational purposes only. I'm here because these are a lot of common issues that I run into in my practice that I see sink young developers in the very beginning of their careers and destroy a project from the beginning. So I'm hoping to convey some information to you to help prepare you for some of the legal issues that you're going to run into as you develop your careers. And then hopefully, if you ever come to me or to another video game attorney, you're not going to have these problems. We'll be able to help you with something that's more constructive rather than something that's sinking your ship. So we will have an opportunity for question and answer at the end. Hopefully we'll have about half an hour. I do ask that you hold your questions until the end, unless you have something really burning, and then please hold it till at least in between a couple of the different segments, wave your hand around. I'll call on you if it seems like you really need to ask. And then please, if you have a particular question, you consult with your attorney. I can answer hypotheticals, I can answer non-specific questions this evening, but if you have something very specific to your situation, I can't help you this evening. So this is what we're going to be going over tonight. I wanted to touch on the three primary areas of intellectual property law: patent, trademark, and copyright. And then we're going to get into the idea of corporate formation, talk very briefly about the different types of entities that you could form, and I'll be doing my best to convince you that you don't need most of them, and that the best is an LLC for the time being. And then we'll have the Q&A. So let's just dive right in with patent. This one is the least applicable to the video game sphere. It protects the law of invention and innovation. And so if you come up with a new and novel technological innovation, some sort of invention or process, often you can get a patent on it. And a patent only is created, it vests in the owner, when that registration is submitted to the U.S. Patent Office and the registration is granted. So often a registration will be done and they'll deny it because they don't think that it's new and novel enough. They think that it might be an obvious innovation. Patent does have a very, very narrow limitation. Now the duration is 20 years from the date of application. So it might take the Patent Office 7, 8, 10 years to issue a registration after the application. So you might only have exclusive right to use that innovation for a decade. So we're not going to be getting in this presentation much further into the idea of trade secret. But if you have an idea, if you have an innovation, something that you really feel like makes your business, the law of trade secrets is really coming up and gaining a lot more importance throughout the world, throughout the United States, and in particular in software development. And that's largely because, I apologize, my text ended up running over here, largely because of a case back in 2014 that actually made it much, much harder to patent a software mechanic. And so before 2014, there were a lot of patents that were floating around where people were patenting software mechanics, where they were patenting the idea as it was expressed in a particular set of code. Back in 2014, the US Supreme Court said, no, you can't do that. That's just a business mechanic here, it's not actually an innovation. Do I necessarily agree with that? No, but that's what the law is now, and so we can't do it. So if you look back, there were some foundational patents in the video game industry. Patents over load games or games on loading screens, and you cannot get a patent on something like that anymore. What you can get a patent on, and where it does come into the video game industry now in particular, is if you're coming up with a new interactive device, if you're coming up with something that would help with if you're doing a VR technology, and it's an interactive controller for VR, or a tabletop controller, something touch capacitive, where that sort of innovation comes in, where it's a physical expression of an idea. It's really patentable now in the sphere. So, not going to spend any more time on patent. Obviously, I'll answer your questions if you have them, but it's just not all that applicable here. I did want to make sure I touched on it, though. Now, trademark comes in, and trademark is the basis for all of your branding. And essentially, it's the exclusive right to use a name, a symbol, or a term to indicate the source of goods or services. We're all familiar with trademarks. We all deal with them in our daily lives. DigiPen is a trademark. And then the complexity comes in when you're dealing with precisely the types of goods and services that you're dealing with. So there are 47 different classes of trademarks, and when you file a trademark registration, you have to very, very carefully analyze precisely what class and what type of goods you're actually being able to get protection for, and then your registration only can prevent someone from using your name in that particular class of goods. So for instance, if one of you decided that you really wanted to go out and make a video game studio named Toyota, Toyota does not have a trademark in the video game sphere. So it is a very clearly trademarked name, and you're probably going to get a cease and desist from Toyota. So from a practical perspective, it's not a great idea, but from a legal perspective, there's nothing stopping you necessarily from doing that. So getting a little further into trademark. So trademark is created immediately when someone begins to use that mark in commerce. And unlike patent, which has a very, very short duration, once a trademark is created, it continues until that mark is no longer being used, or the mark becomes a generic term. So a really good example of that is Kleenex. Has been trademarked now by Johnson & Johnson for decades. And they've been constantly fighting against the cultural usage of Kleenex to mean facial tissues. And whether or not they've actually been successful is a question, but they've at least put up the good fight. And that's been enough for the US Patent and Trademark Office to not declare that their mark has become generic. So there are a couple benefits of registration. So while your mark does inure to you as soon as you start using it in commerce, registration is what really gives that mark teeth. So it creates a presumption that that mark is yours nationwide, and allows you to sue for infringement of that mark in federal court. Otherwise, you're stuck in state court, which has much, much more limited jurisdiction. Similarly, it also opens up the door for damages. So if you have an unregistered mark, you have to prove actual damages. So if someone came in and started using your name, you'd have to prove that they actually caused harm to your brand and actually made profit from their use. Otherwise, you wouldn't be able to collect anything. You'd be able to get an injunction to stop them from using your mark anymore, but you wouldn't be able to collect any damages. Whereas if it's registered, you have the opportunity to collect treble damages. So if you can prove actual damages, then maybe triple it, rather than just being the damages themselves. And there are particular statutory damages also involved. So that starts at about $200,000 and goes up to about $2 million, depending on if the mark is, depending on if it was a willful infringement. And then you also have the opportunity to collect attorney's fees and costs. And this is one of the only opportunities in intellectual property law where you do have the opportunity to collect attorney's fees and costs, because essentially the law is set up in such a way where they presume that if you've registered this mark, they really ought to know that they shouldn't be using it. And so having the attorney's fees and cost provision there really gives a lot of flexibility. So let's talk about what makes a good mark. And so while all of you are thinking about setting up some sort of brand for your video game studio or creating a name for your game, you want to go through a list of, or a thought process about choosing the best name that you possibly can. It's going to give you the strongest possible mark. So the best mark is something that's fanciful. Do you mind, Taylor?
Sure.
Do you mind? So Taylor's a client of mine. And he chose for his studio the name Piggy Bank Studios. That's entirely fanciful. It has absolutely nothing to do with video games, and so it's a very, very strong mark. Similarly, you can have an arbitrary mark, which is, or I'm sorry, that's an arbitrary mark. A fanciful mark is where you just come up with a random name, something that has absolutely no meaning aside from the meaning that you are giving it. So those are two very, very strong marks. So a couple of other examples of fanciful or arbitrary marks here are Blizzard Entertainment, Apple Computer versus Evil. These are marks that have been created and now are associated with this company, but aside from their association with that company, have no distinct meaning on their own. So very strong marks. So suggestive marks are okay, and this is the sort of mark that alludes to or hints at the good or service. So Netflix, it alludes to precisely what the company is. Airbus, Electronic Arts, these are all suggestive marks. I tend to try to steer my clients away from suggestive marks because when you use a suggestive mark, you are towing the line to being a descriptive mark. And we never want to have you go through the problem of, or going through the headache of doing a trademark application just to get a letter back from the USPTO saying, rejecting the application because it's purely descriptive. So to be honest, I'm kind of surprised that Electronic Arts was able to get their trademark when they did back in the late 80s. As far as I'm concerned, that's very descriptive of what they do. But they were able to get. So descriptive mark cannot be trademarked unless it has acquired its own distinctiveness or acquired a secondary meaning. So there aren't very many descriptions of when a descriptive mark has actually gained that secondary meaning. One that is somewhat useful is Microsoft Windows. It describes precisely what the operating system is doing, and originally they weren't able to get a trademark on it, but over time it did acquire that distinctiveness, that secondary meaning of really describing the product itself and attributing to that product rather than just being the idea of a window. So now this is what I really want to get into with you guys, copyright, which is the law of creation and the law of ownership of an artistic work. So copyright is created, just like trademark is created when you begin using that mark in commerce. Copyright is created as soon as that artistic work is set into a tangible medium. So, and then the copyright vests in the author. I very much like you to pay attention to that word author because that's going to be a term that we keep coming back to through the rest of this presentation. Because it's largely one of the reasons why I'm giving this presentation tonight. Last time I presented to a group of video game developers, the question of authorship was one that kept coming up, and so I really wanted to develop the idea of authorship, the idea of very clear authorship, and the idea of joint authorship, of when that comes into play. So the duration of copyright, if you're a sole author, so if you're the only person creating that game, then it's the copyright extends for 70 years past the date of your death. If there are joint authors, then the copyright extends for 70 years past the date of death of the last original author. And if there's a corporate author, so if it's a work-for-hire situation, then it's 120 years after the creation of the work or 95 years after publication. And these dates are also constantly getting shifted out. It used to be 50 years, and then back in the early 90s, Disney was really concerned about Mickey Mouse going into the public domain, and they managed to convince Congress to extend this out. again, and probably happen again at some point, but this is where we are for the time being. And so you've all, I'm sure, heard of the idea of public domain. So public domain is when the copyright, when that duration of that copyright ends, then the work enters the public domain. Now, there are a lot of misconceptions about public domain and what that actually is and what sort of rights that grants to the public to use a work. And then what sort of rights a person can have in the work that they create on top of the public right, or of the public domain work. So for example, Sherlock Holmes is in the public domain, entered the public domain about 30 years ago, and that's one of the reasons why we started seeing all these Sherlock Holmes spin-offs, all these Sherlock Holmes movies. But then the problem is, well, if you're creating something on top of Sherlock Holmes, what do you have a copyright in? What can you prevent someone else from doing? And the decision for that was, it's only the added distinctiveness that you've created. You don't own Sherlock Holmes, you can't prevent anyone else from using it, that's still public domain. And so you have a very, very thin veneer of copyright over the original public domain work. So public domain is great. It's a rich source of ideas, but also it doesn't provide nearly the same sort of depth of copyright, the same sort of depth of protection for your work that creating an entirely original work does. So benefits of registration. So the primary benefit of registration is that it establishes that work as being yours nationwide, prevents you and allows you to prevent anyone else from doing it. And up until very, very recently, one of the other benefits was that it allowed you to sue in federal court to seek particular damages. Earlier this year, in May of this year, the Supreme Court released a decision that essentially said that if you want to sue someone for infringement, you have to have registered. So it's not just that you have access to the federal court, it's not just that you have access to additional damages, it's, yes, you have the copyright, that vests as soon as you create the tangible work. But if you want to stop someone else from using it, you have to register it. So, and then just like with trademark, it gives you the opportunity to seek statutory damages, attorneys' fees and costs, which are substantially more than if you were attempting to prevent someone from using your work if you were suing for copyright infringement without registration. So, what does copyright exactly give you? So it's a bundle of rights that the original author has to that work, and this is the list. So you're the only person who can make copies of the work. You're the only person who can distribute the work, publicly perform the work, display the work, make derivative works from that work, or license or transfer these rights to a third person. If anyone else tries to do that, you sue them for copyright infringement. Now, let's get into then the distinction between sole authorship, joint authorship, and corporate authorship. So in sole authorship, relatively simple concept. You have an individual creator, they're the only person who's contributing to this work. They're the sole author, and they're the only person who can exercise those rights. Joint authors are when you have joint creators, joint collaborators who are all working on this work together. And then the default is, unless there's a written agreement, the default is that all of them share an equal and undivided copyright. So each of them can exercise all of those acts. The only thing that they can't do is grant an exclusive license. Whereas if you're a sole author on your own, you can give someone an exclusive license. A joint author cannot license a work in a way that's then that makes it unusable for the rest of the authors. Corporate authorship is something that you'll probably all deal with in your career at some point soon, and I really want you to understand what work for hire is and what it isn't. So work for hire is a very particular term under the Copyright Act of 1976 that says that any work that's created by an employee within the scope of their employment or by an independent contractor with a valid written independent contractor agreement that is signed, then the ownership of that work vests in the hiring agency, in the employer, in the business, rather than in the worker themselves. And that also has a very, very distinct meaning in that it also strips you as the creator of your moral rights to control how a work is used. And so we talked about the bundle of rights for commercially exploiting a work. Now there's another layer of rights on top of that called moral rights, where you can actually, as an author, control the kind of method of usage, where you can go in and you can say, where you can very, very distinctly control kind of the moral aspects of the usage of your work. And then also it gives you the right to be attributed as the creator of the work. Whereas if it's work for hire, you're not the creator. The corporation is. Even if you contributed distinctly to it, even if you were the primary person who actually contributed the idea or made all of the artwork or something of that sort, the corporation is the author, not the individual. So, joint authorship. I run into joint authorship problems all the time, and they typically come up because people in this industry, it's a very collaborative industry. It's an industry where people like to work together, come up with ideas, share their projects. But then the problem is that, well, when you actually go to commercially exploit a work, if it is economically successful, you might have one of those collaborators then come knocking on your door saying that they contributed in such a way that they should actually be joint authors and share all those rights with you, rather than you being the sole author or the corporate author to it. And so here's how a joint authorship is created. So it has to meet all of these steps, and these steps were established in a case here that I'm not going to bother trying to pronounce, but you can read it here at the bottom. And the factors are, if you have 2 or more collaborators who each contribute independently copyrightable work to a collaborative work, they have no written contract disclaiming that joint authorship, and that each party works to establish their rights as an author by demonstrating control over the creation of the work, a shared intent to be co-creators, and that their contribution had some sort of impact, subjective impact, on the audience appeal of that work itself. These are slightly subjective, and it comes down to that whether or not someone is your co-author isn't going to get decided by you. It's going to get decided by a judge in court after someone sues you when they think that they're your co-author. And so the best way to handle it up front is to, if you are collaborating with someone, make it very clear from the very beginning whether or not you are intending to form a joint authorship work here, or if you are hiring them as in a work for hire situation, or really having a written collaboration agreement stating that they're giving the work to you free and clear, they assign it to you, and that they claim no rights of authorship. If you don't do that, you could very easily have a hit and then have someone else knocking on your door down the line trying to get some money out of you. So, another problem that I run into often is young creatives thinking about fair use and wanting to use someone else's copyrighted material in a way that they believe is fair use. Then they end up getting sued for it. So let's talk about what fair use is. So fair use is an affirmative defense that you can bring in response to a claim that you have committed copyright infringement. And if you establish fair use, then it permits a person to use a work for a couple of very narrow categories: criticism of that work, comment on the work, news reporting related to that work, teaching, scholarship, or research related to that work. And this is determined on a case-by-case basis in this subjective test by a judge. So just like joint authorship, you don't get to decide whether or not your use is fair use. A judge would decide whether or not it's fair use after you have been sued. So be very, very cautious if you go into a situation where you are thinking that you want to use someone else's work. We talked about public domain here and how thin that veneer is. We've talked about joint authorship and how difficult that is. And now we're talking about fair use and just what limited protection that provides. So be very, very cautious when you're thinking about using anyone else's work, and that's including something along the lines of pulling an asset off of Unity or anything like that, because they could come in and claim joint authorship, they could come in and claim copyright infringement, or you might think that you're creating a parody here, but it's not up to you to decide. So go into it with your eyes open. Wow, my formatting really got messed up. Sorry, guys. I really wanted to then touch on entity formation. So these are the common types of entity: sole proprietorship, general partnership, limited liability company, S corporation, C corporation, and a nonprofit corporation. And then just a little bit for each of the characteristics of these. Little bit for each of these characteristics. Sole proprietorship is what's created by default when any individual goes into business. If you just start doing business under your own name or under a DBA, what's created is sole proprietorship. And sole proprietorship has a number of very distinct limitations. It does not offer you any limited liability, and it does not create any sort of entity for you to house the intellectual property of the entity or that you're creating in. General partnership, similar to sole proprietorship, is created immediately when two or more people go into business together. There's no distinction there, there's no limited liability, and when you're dealing with a general partnership, there's also joint and several liability. So if one of your partners makes a mistake and you end up getting sued, all of you are responsible fully. There's no limitation of liability there. So that's one of the reasons why the limited liability company was created. Essentially, back in the early 90s, people really, really liked the ease of use of a partnership and a sole proprietorship, but they really wanted to have a liability shield and a more formal entity type. And so they created the limited liability company, which operates like a partnership or like a sole proprietorship, depending on how many people are involved, but has the ability and the flexibility to assume a lot of the characteristics of a corporation and offers you the liability shield of a corporation. So any business liabilities stop at that entity. So if you do form a limited liability company, if you want to rely on a liability shield, be very, very cautious to maintain the entity in such a way so that no one can come in and just claim that entity was your alter ego. Don't use that entity as your piggy bank. Don't use your personal credit card. Make sure that you're doing business in the name of the entity whenever you're doing that. Otherwise, you're creating the opportunity for someone to pierce that liability shield. So limited liability companies are amazing, but they do have their own limitations. They get unwieldy if you have a large number of people involved. And also investors don't tend to like them very much. Because they are so flexible, it makes it so that investors don't necessarily want to invest in them. Because, well, you have to learn the characteristics of every individual LLC that you're trying to invest in, rather than having one distinct formula that that company has to fit into, which is really the purpose of a corporation. And so the distinction between an S corporation and a C corporation is federal taxation, and we're not going to get into that further now. But functionally, you want to use an S corporation if you're running like a family business, if you have a very, very small corporation, yet for some reason you don't want to operate as an LLC. A C corporation, on the other hand, operates, most entities that we know about are C corporations. Microsoft's a C corporation, Valve's a C corporation, Toyota's a C corporation. And the purpose of a C corporation is that it really provides certainty for investors. They know exactly what they're getting into. There's very distinct administrative burden. There has to be a board of directors. That board of directors has to meet. There have to be shareholder meetings. Those shareholders have a say on how the corporation is run. There are officers, there are shares. It's regulated very highly at the state and the federal level. So it makes it so that anyone who wants to get involved with that corporation knows precisely what they're getting into. But it also has a very distinct administrative burden for the individual. So typically, unless you're really thinking of getting involved with investors or thinking of moving into, or if you really want to offer your employees like incentive stock options, there's really no reason for a small studio to incorporate as a corporation. Limited liability companies are perfectly functional, and down the line, thankfully under Washington law, it is very easy to convert a limited liability company into a corporation. So if you ever get to the point where where you start as a small company, and you get to the point where you want to offer incentive stock options later on down the line, or look at doing any sort of larger investment or offer stock for public sale, it's very easy to take that LLC and turn it into a corporation. Now, nonprofits don't often show up in the video game sphere, but they do every once in a while, because there are video game developers who go into it intending to create games that have more of a social purpose, rather than one that is targeted at just making profit. And that's the big difference between a corporation and a nonprofit. Essentially, when you have a corporation, you have owners, and the corporation is set up to create profit for those owners. A nonprofit is set up to have some sort of social community purpose, and it's because of that mission that the federal government is willing to offer a nonprofit status, which has significant taxation benefits and also allows you to seek grants from other organizations. But you do have to fit in with a couple of within a very narrow sphere in order to be able to qualify as a nonprofit. One corporation, or one type of entity I didn't put up here, because I've never actually seen it come up in the video game sphere, is a social purpose corporation. And that's a corporation it's a for-profit corporation, but it's designed in such a way so that it operates for a social purpose while still being a for-profit institution. So it's kind of a weird melding of a traditional corporation with a mission of a nonprofit, but without any of the tax advantages of a nonprofit. So, why would you want to form an entity? And there are a lot of very, very distinct benefits, and I've just summarized a couple of them here. But essentially, it's when you create an entity, it creates a house for your intellectual property. So it's a very clear way to delineate what belongs to that entity and what does not. It also creates a clear chain of title for all of your intellectual property. So if you ever have to sue someone for infringement, then you're going to have to establish chain of title. And the more assignments there are, the more licenses there are, the more joint authors there are, the more difficult it is to establish who owns that property. So if you start by forming an LLC and having everything owned by the LLC, it makes it much, much easier to protect your IP in the long run. We talked about liability shield earlier. That's one of the absolute distinct benefits of having an LLC or a corporation. It protects the owners from the liabilities of the entity. So if you have a bunch of contracts with vendors, you can end up defaulting on them. If you've been operating your business properly and that liability shield is strong, then your own personal assets are protected from corporate debt. One of the other benefits is working with investors and publishers. Publishers will be a little bit more relaxed about working with LLCs, but a publisher will want to see an entity. I've never had a publisher agree to work with sole proprietorship or a partnership. They want to see that clear chain of title to all the IP. And they want to see that clear entityship. It delineates a degree of maturity in the business. And if they're going to be putting millions of dollars into helping you build your game, they want to see that you have an entity there to back it up. One of the other benefits, and this is something that doesn't come up, or isn't that related to intellectual property, but it does come up often in ownership questions, is it allows you to divide the ownership of the business and that profit between the founders. So essentially, in a general partnership, if two people go into it, it's split 50-50 and there's nothing you can do about it. In an LLC or a corporation, you can decide who owns 60%, who owns 40%, and then you can do particular distributions or particular dividends and distribute that profit in a way that isn't necessarily tied to the ownership structure, or to precisely who owns how much. So it provides a lot more flexibility. Another thing is it creates a defined exit strategy. If you're going into business with someone else, it's always a good idea to think ahead and to lay out a pathway for how you're going to end that business relationship rather than just leaving that for the future, because most business relationships that end don't end happily. They end because something has gone wrong, so you want to define that exit strategy out at the beginning, and then obviously you can revisit it later on. As long as things are amicable, you can always go back in and amend your agreement. But as soon as things start to fall apart, you'll have that agreement in place, and you don't have to worry about then going in and redefining how everything's going to work when everyone's angry at each other. The other thing is that it fits back into intellectual property, into the housing the intellectual property, the clear chain of title. It's a great place for organizing your third-party licenses. So most game developers now have multiple third-party licenses, Adobe, Unity, Epic, all these different sources, places where you're using other people's software, and you're typically paying for the right to use that software. Well, you have a license to it, and so if you have an entity, it's a place where you can organize all of those third-party licenses, so that if there's ever a question about whether or not you had a license to use what you used, you've got it all held in that entity, and it's a much simpler way to keep it all together. So, a couple of takeaways I'd like to make sure that you walk away with. Protect your intellectual property. As video game developers, your intellectual property is the key to your revenue and to your legal power. Don't neglect your intellectual property. Copyrights only provide income if they're being used and exploited. Trademarks are only good for so long as they are maintained and used. Similar to patents. If you don't use them, then there's no reason to maintain them. You can't copyright an idea, but you may be able to patent it. Up until a couple years ago, you may have been able to patent a game mechanic. That's not possible anymore, but you still can patent an idea for an invention or a process. And so if you come up with something that's truly unique, patent is still a great way to go. And patents are incredibly valuable. They put a lot of value into your business and increase that valuation drastically. Collaborate with caution. Your collaborator may become your joint author. Go into it with your eyes open. Make sure you talk about it at the beginning. Establish whether or not you're going to be joint authors. And then it's best to get it in writing that you aren't. Unless you want to be. And if you want to be joint authors, make an entity and agree ahead of time how that joint authorship is going to function. Work for hire means your employer owns the work, and make sure that if you want to hire anyone as a studio, or if you're a creative going into a work for hire environment, and your employer thinks that it's work for hire, make sure there's a written agreement there. Make sure that it clearly states it's work for hire and the justification for why it's work for hire. Otherwise, it won't be. Just as a reminder about fair use, the judge decides fair use, not you. And consider forming an entity. It has a huge number of benefits when you're going into business. Obviously, if you're getting employed by someone, it's not that important, but if you ever plan on creating your own work, if you ever plan on hiring anyone else, that entity provides innumerable benefits and will pay for itself in spades. So, questions? And please remember to speak generally in hypotheticals. I can't answer specifically the questions, but love to take your questions. So.
You mentioned registration nationally. Can you distinct that between like forming? That's something that happens after the fact, I imagine.
Yeah. Speaking about like copyright registration.
Or yeah, or entity registration.
Yeah. So entity registration happens at the state level. So you would decide, which state you want to be incorporated in. Washington is great. 20 years ago, everyone did Delaware because Delaware had a wealth of corporate law and a statute that was very, very beneficial toward corporations. Since then, Washington State has really modernized and created a system that's very, very easy to use. Taylor can attest to that. And very favorable to business owners. So you pick your state, and then you register there, and that creates the entity. Now for intellectual property registration, there are multiple layers of that. And the one that I was talking about in particular here was federal registration. Copyright is registered with the U.S. Copyright Office. Patents and trademarks are registered with the U.S. Patent and Trademark Office. They're very clever in their naming. You can also register a copyright or a trademark in a state. I've never found a benefit to that. because it only protects it within a very small geographic boundary, especially not the video game industry. Can be helpful if you're running a business that only operates in a very, very small area, but none of us are doing that. So, you register federally, and that's a matter of going through a long application process. If it's a copyright, go through that process. Trademark, you submit a trademark application to USPTO. Generally, copyright registration only takes a couple of weeks. Trademark application takes 6 to 9 months. Patent application registration can take, shortest I've heard about 3 to 4 years, can get up to 8 to 10 years, if not longer, just because they have a huge backlog, and they're dealing with highly technical issues. So, does that answer your question?
Yeah, so just to clarify, entity registration happens at formation, basically?
Yeah, so entity registration happens when you submit the paperwork to the state saying, I'd like to register an entity. So
And that's a federal thing that happens?
So entity registration is state. So if you wanted to make an LLC, then...
Somebody else could have that name in another state, basically.
What was that?
Somebody else could have that same name in another state.
They could, yeah. And so if you wanted to protect that name, you'd register the trademark federally.
Okay, gotcha.
Does that make sense? Yeah. Or I think that your hand was open.
Yeah. And this just kind of goes off the entity registration thing. So why, besides choosing the state that might have the most favorable tax laws associated with your industry, what else motivates you to choose your state? Are you restricted in any way based on where you do business? What else
Not
restricts you?
really. So you could register wherever you want to. From a functional perspective, you could register a business in Canada as a U.S. citizen, and then do business in the United States. The complexity comes down to the administrative burden of doing that. So if you're a Washington business doing business in Washington, the administrative burden is relatively low. And you know the laws that you're working with, you have a Washington State attorney helping you, it's all relatively straightforward. If you're a Nevada corporation doing business in Washington, and Nevada has some reasons, there are some distinct tax benefits to being incorporated in Nevada. Then you have to register then as a foreign entity here in Washington. You've got twice the administrative burden because all of a sudden you're doing all your filings for Nevada to keep your entity alive. And then you're doing all of your local registrations to let Washington know that you're doing business here, to pay your property, or to pay your taxes, keep your license up to date and all that. So, did that answer your question?
Yeah, a little bit, yeah.
Or you were, yeah.
So I got.
Good to sound keeper. For sure.
All right, I got you can't copyright game mechanics, but didn't quite understand what you can copyright. Like